Good morning, Professor and classmates. Today I will give my presentation about the initiation of proceedings, preparation for trial, and trial proceedings. Here is my table of contents. First is the charge and arrest, and second is preparation for trial. And then I will talk about trial procedure, which include the trial procedure in outline, the role of judges, rules on evidence and control of proceedings, deliberations, and sentencing. First, I will talk about the initiation of the proceedings, and I will begin with the initiation document. Proceedings against an accused as ICTY, STR, RCL, and STL commence with indictment. For the reason is that the confirmation of charges against a person before this court is one-step process conducted in judge's chamber without the involvement of the suspect. Only when the indictment is confirmed may an arrest warrant is be issued. However, this procedure is different from the ICC. The procedure is inverted at ICC, where the initiating document is a request for an arrest warrant or summons. The procedure in ICC is like that. First, the prosecution seeks an arrest or summons. Only once a warrant is executed or the person appears before the court may the conference process proceed. And the standard for the issuance of the warrant or summons at ICC is broadly similar that the reasonable ground to believe, but then rests to substantial ground to believe for the confirmation of the charges. Here we come to the confirmation procedure of charges. First, at ICTY, a single judge designed by the president of the tribunal reviews the indictment, which we talked before like that. The suspects are not involved in this procedure, and the judge will review the indictment. And based on the result of the reviewing, the judge may confirm the indictment or dismiss it. Besides, the judge can also request a prosecutor to present the additional material, and also can join the review so as to give the prosecutor the opportunity to modify the indictment. And as a result, if the indictment is confirmed, the person becomes accused and an arrest warrant may be issued. Also, we can see the ICC. The ICC procedure is different from the other tribunals. First, the pre-trial chamber shall hold a hearing to confirm the charges on which the prosecutor intends to seek trial. The hearing shall be held in the premises of the prosecutor and the persons charged, as well as his or her counsel. So the person be charged can just involved in this procedure. And the document containing the charges must be disclosed no later than 30 days prior to confirmation hearing itself, to let the person accused have some time to prepare for it. And the pre-trial chamber shall, on the basis of the hearing, determine whether there is sufficient evidence to establish substantial ground to believe that the person committed each of the crimes charged. The ICTY and other tribunals should, as ICTY and ICTR, the pre-trial phase occurs following the issuance of the indictment. and but at ICC, the pre-trial phase at ICC consisted of two steps. The first is the confirmation phase, which we talked just last, and the post-confirmation phase, when the people becomes accused if the charges are confirmed. Many of the procedural steps and disclosures that are required for the confirmation hearing carry over to the post-confirmation phase and assisted in trial preparation. The disclosure is important in the prayer for trial procedure. It is the process by which information in the prosecution's possession handed over to the defense so that it is properly informed of the case against accused and can provide a proper defense. The quantity of disclosure is a determinant of time needed to prepare for trial and of the duration of trial itself. There are same four categories of information must be disclosed at all the international criminal tribunals. The first is the material submitted to confirm the charges. Or in the ICC, you can see the material submitted to insurance of arrest warrant, or statement of prospective trial or confirmation hearing with witnesses. Also, the information that is material to prepare of defense is important. And the last one is exculpatory information. Besides, the prosecutor are required to submit a pre-trial brief before the start of the trial. The pre-trial brief serves as a blueprint for the presentation of the evidence. Also, the brief presents the prosecutor's case theory in more detail than the indictment, and the testimony and documentary evidence to be relied upon to prove the charges, and a list of witnesses and documents to be relied upon must be included. So the prosecutor's case theory and the testimonial and documentary evidence and the list of witnesses and documents to relied upon to prove the charges should be present in the pre-trial brief, which should be submitted by the prosecutors before start of the trial. Here we begin the trial procedure. The first is I will talk about the evidence. The sentence of the sequence of evidence. The guilt must be assessed exclusively on the basis of evidence admitted at trial, which is a principle. So the most important aspect of the procedure is the sequence of the presentation of evidence. Even the procedure in Connect is important. The ICT and SCL rules expressly require the prosecution to present its evidence first, reflecting the principle that the accused ought to know that the entire case against him before having to present evidence. But the ICC statute does not expressly set a sequence for the presentation of the evidence. It just generally empowers the judge to give directions for the conduct of proceedings, include ensure that they are conducted in a fair and impartial manner. And oral testimony is important because all of the international courts recognize that witness evidence is to be given by the way of oral testimony before the judge. The procedure is like that. First is the party calling the witness to examine the witness through no leading or no suggestion questions. and followed by the advice party to give cross-examination if it wishes, can leading questions or propositions. And last, the party called the witness to re-examine the witness on the matters raised for the first time. During the cross-examination, only no suggestion questions. The difference between the leading questions and no leading questions is that whether you can answer it with yes or no. For example, no leading question is like that what was the color of the car, and you just can answer the color of the car like yellow, red, white, black, but you can't answer it with yes or no. But the leading question is like that. Was the color of the car is yellow, and you can answer it with yes or no. And and uh, and it can say that the leading questions may the leading questions may challenge the witness's credibility because the witness can just answer the question with yes or no. Here is the role of judge. Judge is important in the tribunal. Like we just talked before, it gives some directions and control the proceedings of the tribunals, so it can potentially play a significant role in the presentation of evidence. It also has some broad power in to directing the questioning of witness, ordering protective measure for vulnerable witness, determining the appropriate line before proper confrontation and harassment. And the judge also decide on written or oral motion submitted by the party with respect to the questioning of the witnesses. The role of evidence applied at trial are a means of controlling arbitrary retroactivity in the manner of these investigations and of ensuring at least a basic standard of reliability and relevance. There are three broad principles governing the general admissibility of evidence before the modern international criminal courts. It's like that all the evidence admitted to the court must be relevant to the case, and it should have probative value. And practical evidence on the trial fairness is important because the protection of vulnerable witness is one of the special significance in the international context, and measures may often need to be taken both the inside and outside of the courtroom to ensure that the security and dignity of those people to be protected, while at the same time not prejudicing the right of the accused to be a fair trial. So the admitted of evidence and the evidence itself and also the procedure you get the evidence should be fair in the tribunal. And also we come to also we have to know the proceedings of the tribunal have to be controlled to make sure the persons in the tribunal and the tribunal itself and all of them should be the dignity and security should be made sure. So the trial chamber may close the hearing to the public when necessary to protect victims or witnesses and public order or morality, security, or the interest of justice. Persons, including the accused, may be removed from the courtroom to maintain the dignity and the decorum of the proceedings. When the both parties have completed their presentation of the case, The court declares the hearing closed and retires to deliberate in private on the basis of trial records. The standard of proof to be applied is to prove all necessary elements of the crime is beyond a reasonable doubt. And the sentencing is not a fact-specific procedure. Instead, it should take into account such factors as the gravity of the crime and the individual circumstances of the convicted person. Any and all circumstances may be taken into account in reaching a determination of appropriate sentencing in view of accused contribution to and gravity to the crime. So we must take some reasonable factors, the crime and the the accused person itself, and the circumstance of the convicted people, and some related factors to make sure we get the appropriate sentence to make sure the fair. Okay, that's all my presentation. Thank you for your listening.